Now the question is, in what mode is this resistance to be applied? I mean, okay, so he's shown us that the Virginia resolutions are calling for resistance, but what kind of resistance? Well, the context and the wording of the resolutions make clear that Madison envisions a resistance that will preserve the Union unimpaired, but at the same time put down the usurped power. And it must be undertaken, the interposition of the state must be undertaken in such a way as to arrest the progress of the evil. Now, Upshur says, this is very significant, he says, "It is to be remarked that we have here a distinct declaration that there is within the Constitution of the United States some principle by which the encroachments and usurpations of the federal government may be resisted. I say within the Constitution and not extra-constitutional and revolutionary," okay, which is the argument that you hear today. So then Upshur goes and looks at all the different types of resistance other than nullification that could exist, and shows that every single one of them falls short of the criteria laid out by Madison. It says, for example, petition and official remonstrances and protests. He says this is not resistance at all. He says petition is a simple appeal for mercy and forbearance. Petition and protests affirm a right and threaten the enforcement of it, but they do not in themselves enforce it, and therefore are not resistance. There is, in addition, the appeal to arms, violent resistance. But Upshur believes this is only for an extreme case, and certainly if the usurpations of the federal government are to be met only by an appeal to arms every single time, well, number one, either we'll just never have peace, or that will be viewed as such an extreme measure that no one will ever resist, because most of the time people will just prefer to continue living their lives and not be bothered by this type of turmoil. Another possibility is repeal of the unconstitutional law by Congress, to try to get the unconstitutional law repealed. But Upshur says it's not likely this is going to work. It's not likely that the usurper is either going to acknowledge the usurpation or lay down willingly the usurped power. And he says you must remember, too, that the usurper in the present case, he's talking about, he's talking about the tariffs in 1833. He says, you must remember the usurper in the present case is a majority of the people, usurping upon the rights of the minority. And the history of the tariff laws ought to convince you how unapt such usurpers are to give way. This remedy, therefore, would be of little value in practice. Besides, it is in principle a simple appeal to the wrongdoer, and is therefore no more a mode of resistance than the right of petition. Everything is left at last to the will and discretion of the usurping power. I should just mention parenthetically that in 1833, Upshur is talking about nullification in the context of South Carolina's nullification of what they consider to be unconstitutional federal tariff laws. And they are appealing to the Virginia and Kentucky resolutions of 1798 in so doing, in nullifying federal tariff laws. And so Upshur, in that context, is talking about those resolutions. Another possible mode of resistance is to amend the Constitution. But again, for Upshur, this misses the point, because the problem, he would say, is not with the Constitution itself. What we want to do is preserve the Constitution, unimpaired as it is. The problem is we've had a breach of that instrument. So an amendment to the Constitution misses the whole point. And then finally, secession. Well, he says secession, whatever the legality of it, the point is it does not seem to meet the conditions called for by Madison, because it is not a mode of resistance that preserves the Union unimpaired. Instead, it is a running away of the oppressor. And far from arresting the progress of the evil, by removing a resisting state, it's actually enabling the evil to continue. It removes all restraint from the wrongdoer. So, the only option left, according to Upshur, is nullification. Madison's language and words do not admit of any other construction, regardless of what he said later in his life. Now, a final point from Upshur is that nullification does not proceed upon any supposed right of the state to repeal a constitutional law, but upon the right of the state to declare that an unconstitutional law really is so, and to refuse obedience to it for that reason. He says, remember that a law beyond the Constitution is no law at all, and there is no right anywhere to enforce it. A state which refuses to submit to such a pretended law is strictly within the Union, because she is in strict obedience to the Constitution. Now, the other states responded to the Virginia and Kentucky resolutions. At least some of them did. Most of the southern states did not, but the northern states, a number of them did, and all unfavorably. Massachusetts issued an official report sharply condemning these ideas, saying they're unheard of, they're novelties, they have no place in the American constitutional tradition, so on and so forth. Now, this is a point that we'll take up probably tomorrow morning, because what we're going to see is that those states themselves that were so vocal in 1798 about how crazy these ideas were, and no one could possibly use them, within 10 years they were using. And they were using some of the same language that Virginia and Kentucky used in 1798. So you get the impression that at least some of the reason they were against the Virginia and Kentucky resolutions is that they liked the Alien and Sedition Acts. They were hotbeds of federalism there. They liked the legislation. They didn't like this proposed means of resisting it. One of the points that's consistently made in what we've just looked at and in the discussion of nullification is the idea that there is no common judge that can adjudicate disputes between the states and the federal government. And to say that the Supreme Court is a common judge is to miss the point entirely. Because as Jefferson would say, the Supreme Court is part of the federal government. I mean, those people get their salaries from the federal government. They're in the pay of the federal government. That can't be an impartial arbiter in a dispute between the states and the federal government. It would be rendering judgment in a case to which it itself is a party. So in no way can that be considered legitimate. Jefferson had made this point all along. You can pursue this in. There's a book from I believe the early '90s by Quirk and Bridwell, if I remember the authors correctly, called Judicial Dictatorship, published by Transaction. They point out, as obviously many authors written on Jefferson's thought have pointed out, Jefferson does not believe in judicial review. He doesn't believe the Supreme Court ought to have a monopolistic privilege on interpreting the Constitution, because then that simply means that they're running the country. Because if they get to interpret it and they have the final authoritative word, well, then they dictate. They know if they get to say what the Constitution means, then they're running the country, and it's very dangerous to entrust so few people with that type of power. So he doesn't like that. He believes in something called concurrent review, whereby all three branches of the federal government have a responsibility to maintain constitutionality. So that even if the Supreme Court upholds something, but the President believes it's unconstitutional, he doesn't have to bow down before the Supreme Court and say, well, I guess I have to just get rid of my scruples about this. The Supreme Court upheld it. He has a responsibility not to sign it. And likewise, the Congress should not pass something they believe to be unconstitutional. So that was Jefferson's take. He does not believe there's a common judge ruling over that can adjudicate disputes between the states and the federal government, and the Supreme Court does not count. It would be as if we said, I'm having a dispute with you, how are we going to resolve it? And I said, well, you know, my brother Sal will adjudicate it. I mean, like, you wouldn't agree to that because obviously Sal is going to have a difficult time being impartial. And in such cases, more and more the federal government will rule in favor of itself.